in Smithtown, New York, constitutional expert and attorney Andrew Lieb. Thank you both for joining me this evening. And Andrew, I'll start with you, because really what I'm looking for initially is just hoping that you can put this into context for us. We know this is the first time. We've heard that over and over. But more so for the country, the context of having a president have to appear in court on a felony affidavit.
Michael, it's wild, it's historic, you said it right, and the most interesting thing to me was when I read the statement of facts and I learned some of the facts underlying the charges happened in the Oval Office when Donald Trump was president. So it's not just he's a former president, the facts are about things that happened while he was president. He didn't have to have a mugshot. He didn't have to wear handcuffs, but at the end of the day, Donald Trump was treated like anyone else in an arraignment, having to plead not guilty and getting warned about the rules about going on social media by the judge. He was very somber in court today. That's what the pictures said to me.
Bernardo Villalona, one of the things that jumped out at me about the document was that there seems to be at least some recordings of the president himself. They're not just relying on, I guess, the testimony of others. But what jumped out at you reading those documents today, as I know you have?
Definitely. So the indictment itself, at least today, we know what the counts are, and that it's a felony indictment, that all 34 counts are felonies, and it's not felonies and misdemeanors. But the statement of facts did give us further information. We know that the whole focus of this investigation and the crust of it has to deal with the payment that was made to Stormy Daniels for the purpose of quieting her to the extent that they did not want that story to leak out because it could have affected the campaign itself. And I think what stood out to me the most in this entire statement of facts, and also the interview, the press conference that was done by Alvin Bragg, is that he made it clear that this action, why he was going forward, and the importance of it is because it affected the election itself. Had this story came out, it would have influenced the election results.
Andrew, let me ask you this question, because essentially at the heart of these charges is this former president, during the time of an election, misleading voters. That's essentially what this plan or this scheme, which is the basis for these charges, was all about. So is democracy a winner or a loser today?
It's a real toss-up to me, Michael. I'm befuddled is the right word for what's going on right now. There were two things in that statement of facts that led me to believe exactly what you're saying that stood out particularly. One was they talk about the Access Hollywood video and that coming out and how that showed how he was losing support and how it was so important to pay off another one of these people coming forward. That was one real major thing that I saw there. The second one is they said, hey, you need to delay the payment. Maybe it will make it as long as the election's over. Delay. It all tied in, Michael, to this getting elected. And I wonder today if Donald Trump would have won the presidency but for what happened today. I guess we'll never know.
Yeah, all right. You know what I want to do now? I want to bring in the actual law that's being used to bring these charges so we can sort of get a sense of what it requires here. Now, a person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree, and when his intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. So there you see that sort of double thing happening there. Falsifying business records in the first degree is a Class E felony, generally punishable in New York, I believe, Bernardo, by 1 to 5 years. But talk to me about what New York State has to prove here. There's a sense that, you know, he may claim he didn't know what was going on. Others were taking part in this. Others were helping him. Just how difficult is it going to be to prove this?
So when we break it down to basics, what we need to show, what the prosecution is going to have to show in this case, if that, number one, there was a falsification of business records. So Alvin Bragg has already said that there were already 34 false statements that were made either on checks, on ledgers, or on invoices itself. And what made it false? That he supposedly paid out $130,000 for legal fees to Michael Cohen, and that it wasn't actually for legal fees. Instead, it was repayment to Michael Cohen for the money that Michael Cohen had paid out to Stormy Daniels to quiet her about what happened, about that affair. So that was the purpose. If we break that down right there, is the intent to defraud, and that is to mess up with the records and those false statements in the records. But the reason behind it is that so people won't find out, for him to actually conceal that crime, for him to conceal that a payment was being made in furtherance of the campaign itself. What's going to make it a little bit easier, and I have to say that shocked me from looking at the statement of facts, is that Donald Trump, for at least 2 of those repayments to Michael Cohen, it came out of his trust. Personal trust, the Donald Trump trust. It's going to be very difficult for Donald Trump to say, I had no idea what was going on. I didn't know he was being paid. Oh, I just saw that it was legal fees. Why did it come out of your personal trust account? And then the other payments came out from Trump Organization. Yeah. So that's what the prosecution is mainly going to focus on, is Michael Cohen's testimony, as well as the testimony from AMI, as well as getting corroboration to corroborate all this testimony, so that way they can bolster up and make credible Michael Cohen, who we already know has credibility issues.
You know, Andrew, at the end of the day, this case is going to boil down to, from my reading of the documents and some of the rhetoric being put out there by Trump's defense team, it's going to really come down to a he said, she said on some level, or he said, and basically the other side is a convict who's already been convicted of this crimes involved in this offense, and also a former porn star as well. You know, when you start putting the two together, words of a former president versus that, I mean, if I'm his defense attorneys, I'm liking my chances a little bit.
Well, I think that if Bernardo was the prosecutor, he'd be in a lot of problems, because the way she outlined it, I really saw a problem for Donald Trump, because the key isn't that it's Michael Cohen versus Trump. The key isn't that it's Stormy Daniels versus Trump. We have Stormy Daniels. We have Karen McDougal. We have the doorman. There's 3 different characters there. Then we not only have Michael Cohen, but we have David Pecker. And then we have this third lawyer, who I think might have been Castello. We have all these different people involved. But what I thought was the most telling, Michael, is when we saw the press conference from Alvin Bragg, he specifically said that the indictment didn't specify the underlying crimes, the other crimes, because he doesn't have to do it. So we're all guessing still what he's going at. I see conspiracy. I see tax fraud. I see election interference. There's all different ways that he could skin this cat. And when you don't know what the prosecutor's skinning, you got problems as a defense attorney.
Yeah, Bernardo, I think he might be right here. At the end of the day, as I'm looking at it, he's saying, you know, when the charges basically come down, when you look at falsifying records, those are generally misdemeanors. But when they are coupled with other activity, for instance, concealing other crimes, then they become a felony. Do you think that might present a problem?
Exactly, and that is the biggest problem, because if we were just talking about putting false entries into his business records, into his checkbook, into the ledger, and into invoices, then it would have been just a misdemeanor, where the most he would have faced is 1 year incarceration. But when we bump it up to that felony, when it's the intent to conceal a crime or to commit a crime, and just to be clear, they don't have to prove up that crime. They just have to prove that there was an intent to conceal it or to actually commit a crime, and they don't have to be specific as to what the crime was. So with that being the case, I think that there's enough evidence, just reading from the statement of facts and going into my prosecutorial experience of what else can be back in that grand jury testimony and what was presented to the grand jury. There's more than enough to find Donald Trump guilty. The question would be, because we still have other open investigations and possibility of other criminal charges, is which case is going to go first? Because just because New York indicted Donald Trump first doesn't necessarily mean that that will be the first case that will go forward with a trial.
That's an excellent point, and Andrew leads me to my next question. Bernardo's referring to a couple of other cases, I think on the federal level, regarding that January 6th event, but also charges in Georgia involving his sort of meddling or alleged meddling into the election in that state. Both of those, it's possible. Now, we've talked a little bit about this idea that nothing in the Constitution based on these charges would stop him from continuing to run. But those other charges, it's possible the Constitution may have something to say. If he's convicted of those charges, let's say those go forward first, those could potentially have an effect for him to sit in office or either run for office based on the fact that they could be considered actions against the country.
Yeah, Michael, it's a legal theory that people are toying around with. I'm not sure how far it's going to go. You're talking about in the 14th Amendment, it says if you are going to be doing something along the lines of sedition, you're going to try and do what January 6th, what we're hearing media talk about January 6th, you'd be ineligible to serve in all offices, including being the president, except, and this, I think this is a cool interesting point that's unknown, if 2/3 of the Congress says that you are now able to do it. But it's a real fringe thing because we haven't seen it happen before, and it really depends on what those charges are brought when you reference the January 6th. And I don't want us to forget about one more case. We still have the classified document cases, which also could fall into that line under Jack Smith with the special counsel from the feds.
All right, fair enough. Bernardo Villalona, Andrew Lieb, you're going to be staying with me. Now, when we come back, folks, more on Donald Trump's arraignment and the 34 charges he's facing, plus